upon what he has been told by the alleged victim. In this case, the alleged victim has given I don't know how many different interviews to media, to the newspaper, to television, and there is in the case sufficient discrepancy in things that she has said that would make one know, would make the court know, that would make a person who has looked into it know that there is a huge dispute as to what happened up on that mountain at the time that it occurred. And so the nature of her comments and what she has said about the facts and the change of her facts and the discrepancies in that throw great doubt on her credibility. Of course, the court cannot decide that here today, but you have a situation where there's a presumption of innocence. There, in my judgment, is no question Jennifer Bragg will show up at hearings. Then you take into consideration as well the criminal record, it says, of the defendant. Well, I'm sure that the prosecutor can get up and say that Jennifer Bragg has been arrested numerous times. But if you look to those arrests, almost all of them were dismissed. I believe that if you were to look to that which exists as to her, there's only been 4 things, I think, that she's been actually convicted of. And two of those were DUIs, one of which was 16 years ago, I believe. One of them was an obstruction of an officer. And back when she was going through her divorce and was being, she said, threatened by her husband, I think they picked her up one time for carrying a concealed weapon. So I don't, in my judgment, conclude that it's a criminal record if the case has been brought before a judicial body and has been dismissed. And I don't think the court should count that. I guess the court always presumes that Judge Hope knows the law, because I know that he does. And the citation on that Hutzler v. State Extra
164-12.
Okay, yes, you've got it.
Yes,
you have that.
Yes.
And so with that, Your Honor, I would submit to the court that this bail that has been said is just, it's excessive. It's contrary to Article 3, Section 5 of the West Virginia Constitution. It's contrary to the 8th Amendment to the United States Constitution. And it's no bail at all.
Okay. Mr. Prosecutor, do you want to respond alternatively, or do you want to respond collectively?
Whatever pleases the court, Your Honor.
Well, in that case, let's individually, even though it's the same set of facts and all these things. One of the things that Hutzler does say, because it's against Judge Doster out in the Eastern Panhandle.
Is that how you pronounce it?
Yeah. Well, he's the fellow that rode around on the helicopters with machine guns and stuff. So it was a little different, number one, in the Doster case. And number two, they did not, in any way, shape, form, or fashion, modify State Ex Rel against Johnson. Keep going. Yeah, if you want to respond to
and again, I know you're familiar with this, Bragg, and I don't say that. I mean, in other proceedings, not necessarily all of them are not criminal. So I don't. Right. I mean, the court's obviously. I certainly don't argue with Mr. Green that Ms. Bragg is a lifelong resident of Lincoln County. To my knowledge, she is a lifelong resident, and so I certainly don't argue with that. I would note that this this incident, which we talked about the seriousness as an offense, and this is a very, very serious offense. Again, it doesn't arise out of it's not out of out of the blue or some random act of violence. The defendant and the victim have had a substantial history of problems with each other, and in fact, I would note that at the time that this occurred, Sprague was on bond for at least one other incident in relationship to the victim, and was on bond for another DUI third offense at the same time that when this occurred. So there were, you know, and I understand that, and I agree that the primary issue with bond is to assure people that show up, but it is not the sole issue. I mean, there are obviously some ancillary issues with bond. Number one, making sure that people will conform to the law, and I think Ms. Bragg has illustrated that has been a real problem while she's been on bond in the past, and she's she's charged with one of her co-defendants, Mr. Cremesian. They have intermittently during the last year had problems on and off, and people have been charged and then they've been dismissed, and that's also gone back and forth. So I would note that I think Dale correctly stated what her criminal history is, but there had been a substantial amount of charges filed, some of them just dismissed as part of reconciliations and so forth. But again, I would note that in relation to the seriousness of the offense, this does not come out of a vacuum, Your Honor, that it was just some random happening, and I don't think either side would agree, whether we don't agree with the facts on how it happened. Neither side, I don't think, would argue that it was a random happening. There is a substantial history and a dislike between the victim and the defendant that led to this incident. It's our position that, and again, I haven't seen all the statements. I know the victim has talked to certain press. I haven't seen them all, but I've talked to the victim myself. To my knowledge, the victim's never waned on the fact that these three individuals were all involved in the beating that led to her. And again, she was very seriously injured, Your Honor. She had to go to the hospital, and I think she's still facing some reconstructive issues as far as her surgery goes. You know, I don't think, again, while we might disagree to how the injuries occurred, I don't think anybody disagrees that there were some pretty serious injuries in relation to Ms. Boggs that occurred out of this incident. Again, I go back, Your Honor, that you know, they're charged with malicious wounding, attempted murder, and again, that is the position of the state that was the intent of the parties. And again, I'm not here to argue the facts too much, but I think the court has to have some background that the victim was beaten up, and then it's be the position of the state that she was left for dead by these defendants, that the victim was able to make her way out and get somewhere where she could call and then be taken to the hospital. And so there's no current indictment. My anticipation is when it comes time to do a grand jury investigation report, that the charges that currently stand are the ones that will be presented to the grand jury. And I said, you know, other than the fact that Ms. Boggs has died, these are about as serious as allegations as you can get. Again, that I think the court can also factor in relation to the issue. I mean, if released on bond, is there some potential for future problems? And I know the victim was scared to death that the defendants are going to get out. And again, based on the fact that these are just starting out of the blue, that you know that the victim and the defendant didn't know each other, I believe there is some chance, even if they were on home confinement, if they were released, that there would be some more altercations in relation to this very same incident. Again, as I said, the allegations, other than had Ms. Boggs died, are about as serious as they come. And as I said, the victim, while I haven't seen every statement, she, as far as I know, has been consistent about the fact that these defendants, including Ms. Bragg, were the ones that levied the beating on her, that led her to go to the hospital and led her to receive the injuries she had. And I know, looking at it in a vacuum, I can see how somebody might see that the bond is pretty high, but every now and then there's an instance when a bond needs to be pretty high, and I would submit to the court that this is one of those instances, Judge, where a significant bond is supported by the facts. And again, that this is something out of the vacuum. This is something that historically has one of those deals that was a powder keg that finally blew up. And you know, I certainly don't want to see any more instances while we're trying to get this thing to trial. So I would respectfully request that the